Welcome to Advanced Trial Tactics, tips from experts on motions in limine. My name is Edward Weiss. I will be moderating today's discussion. I'm delighted to introduce our impressive and highly accomplished speakers today, the Honorable Randolph Hammock, Jay Spillane, and Paul Kiesel. Judge Hammock is a Superior Court judge currently sitting in an independent calendar court at the Stanley Moss Courthouse, in which he presides over unlimited civil cases. During his almost 25 years of practicing law, primarily as a civil trial attorney, Judge Hammock was admitted to and actively practiced law in a total of 15 states, as well as over 20 federal district courts and courts of appeal. As such, he is likely to have had passed more bar exams than any other practicing lawyer in the United States. Jay Spillane is the founding shareholder of Spillane Trial Group, PLC, a firm of business trial lawyers representing private companies and individuals in bet the company cases. For over 3 decades, Mr. Spillane has tried cases for entertainment and sports personalities such as Robert Redford, Harold Ramis, surf champion Kelly Slater, and beach volleyball gold medalist Kent Steffes, and for companies and high-level executives in cases involving entertainment, intellectual property, technology, real estate, finance, corporate control, and family wealth. And we also have Paul Kiesel, who is a nationally recognized trial attorney with decades of experience representing consumers in complex litigation.
That's enough said. That's no more. You got that. Perfect. Anyone can find me later. Keep going. Sorry.
Including personal injury, class actions, environmental cases. He's an early adopter of legal tech and co-author of key legal treatises. Paul brings deep insight into building and sustaining a successful modern law practice.
Thank you.
And for myself, I'm a neutral with ADR Services. My background is I practiced business litigation at Manette, Phelps & Phillips. I was an assistant U.S. attorney in the criminal division here in the Central District. I spent about half of my career at Ticketmaster, where at various times I was general counsel and oversaw litigation, including trials where motions in limine were involved. So that's how I landed on this as the moderator on this august panel. So let's get started. For an overview of motions in limine, Jay, what are they for, and what are some tips and do's and don'ts?
All right, well, thank you very much. So let's cover the absolute basic. A motion in limine is a written motion filed before trial. It's a fully briefed bond motion like anything else. The motion, memorandum, opposition, reply, typically set for hearing at a final status conference, final pretrial conference. The judge may or may not hear it on that day, or may reserve it and see if the parties settle. But these would be resolved, if not at that final pretrial conference, then before the jury is brought in. The classic use of a motion in limine is to exclude evidence that one thinks should not come in, and it would be the type of thing where it wouldn't lend itself to standing up and just objecting right there. You may or may not have enough time to fully explain why it's not admissible. Something could come out in front of the jury, and then it's hard to unring the bell. So you want to sort of write this up and have the judge really think about it before you get there at trial. Now, there's some basic requirements of motion in limine we all ought to keep in mind. We have in the outline, and some courts expressly require people to affirm that they're following the principles well explained in Kelly versus New West Federal Savings. We have that citation in the materials. And what are some of these broad principles? First of all, the motion should be directed at a specific identifiable piece of evidence, right? We don't want to burden the court with motions for general propositions, like a motion to exclude evidence that isn't relevant without specifying what specifically you think is not relevant. A motion to prevent the other side from introducing a document that wasn't produced during discovery. Well, no, that's too general. You have to you have to talk about a specific document you think someone's going to bring in and explain why it was requested, discovery, and not given. Another common misuse is what's really a de facto motion for summary judgment, although not described as such, and using the detailed procedures as such. For example, let's say in an employment case, the defense says the plaintiff really doesn't have enough evidence of discrimination so that we want a motion barring them from telling the jury they should return a verdict or they suffered any damages. Well, that's not really a motion to exclude a specific piece of evidence. That's effectively a motion to throw a cause of action out without following the rules of summary judgment. So that should be avoided. Now, in terms of my practice, look, I find that there's only so much time in a trial, right? We're going to be there, 4.5 hours a day, how many ever days the trial lasts. Not only are there so many things that you can get a jury to focus on, but there's only so many things you can get a judge to focus on or want the judge to have to struggle through. I mean, our good LA Superior Court judges are struggling with, I'm sure Judge Hammock will tell us, my impression it's 1,000 or 2,000 cases, especially because the injury cases are floating back in. So you don't want to flood your judge with 20 motions in limine. I like the number 3. What are the 3 things I want to make sure the jury can remember? And what are the 3 things I really want to bring in front of the judge that should either stay out of evidence or come into evidence? So I like to focus on something that I think is really high impact and effective, that really underscores a couple of important themes about my case. Now, one of the things we mentioned in the outline is, and I encountered this, being a business trial lawyer as opposed to an injury lawyer, I get my share of arbitration clauses. I get references because it's a complex accounting. Sometimes if there's no real emotional issue and it's a bunch of financial stuff, people just waive jury and it's a bench trial. A primary purpose of a motion in limine is having mentioned, unringing the bell. You don't want to get something that you don't want the jury to hear out there in front of them. Technically the judge says, please ignore that, but they've already heard it. It can be hard to unpack. With a bench trial or an arbitration trial, the judge is going to be more objective, training these kind of things. Unringing the bell is easier where the judge is your trier of fact. So I don't do many motions in limine in a non-jury proceeding.
And Jay, let me stop and ask the question, because I don't think I've ever done a motion in limine where the trier of fact was my judge, that I'd be sharing what the motion is, because the whole idea is to unring the bell, and you don't want the judge is going to hear it, right?
Right. Yeah. I mean, in preparing for this, I couldn't. I went back and I made notes as to some ones I'd done that we may talk about later, and they were all in jury trials, right? So
exactly.
So yeah, I'm hard pressed to think of one. I mean, I suppose if there's something just really complicated, maybe one thing that requires a lot of briefing and exposition of what there's some dispute in the appellate authorities, maybe that's something that might be complicated enough. But otherwise, I think you can just talk about it at the hearing, and the judge is going to understand why they should ignore it. Yeah, I agree with that. Let me see if there's anything. I think those are the main points I wanted to make just on an overview. Edward, we're going to turn it over to the judge, or
Yeah, that's
Yes.
great. Thank you for now, Jay, but don't go anywhere. Judge Hammock,
Yes. Well, let me follow up on that last.
maybe you could begin by telling us about the outfit that you selected for today.
Okay, this is you could do this in the chat later. You're gonna guess what my costume is. It actually is a specific fictional character from television. Okay, don't shout it out. You could type it later, there'll be some sort of small award of free continuance in Department 49 for anybody that gets it correct, okay? And just to give you an outline, I'll give you the whole costume. There it is, okay? And it took me a long time to gain all the weight to fit into that costume. Decades, okay? So I'm committed to this costume, okay? So put it in the chat, okay? Now let's turn to reality. Let me follow up on that one point that council, they both just talked about. You know, I've been doing this, I've been a judge for 17 years. I was a lawyer for 25, so 42 years, civil litigation. Always, of course, I know what a motion in limine is, but I always said to myself, where is that from? It ain't in the CCP. The word motion in limine doesn't even appear in the CCP. It appears once in the rules of court. I just found it. Rule 3.1112F. And it's literally one sentence. It says, notwithstanding A, which doesn't apply, a motion in limine filed before or during trial need not be accompanied by a notice of hearing. The timing and place of the filing in service of the motion are at the discretion of the trial judge. So, CCP, rules of court, the only time motions in limine, the word motion in limine even appears. So a lot of times I've had a case where 80 motions in limine were filed, 80, 80, okay? And the first thing I say, where's your authority for even me hearing a motion in limine? Okay, they're all like dumbfounded. Now, the local rule does talk about measure. Okay, there is a local rule, write it down, 3.57, okay? Los Angeles Superior. So that's where it comes from. It comes from our local rule. And believe it or not, the case law that I found, it's all based on our inherent authority under 128. Wow, we're really straight. Whenever you start citing me 128 of the CCP, I know you're desperate, okay? Because that's the catch-all. Inherent authority to control my proceedings, okay? Inherent authority of the court. So that's where that came from. And the local rule is very specific. Please read it and follow it. That's critical, okay? So, for example, if you're in my court, almost every IC judge has a pre-trial, a trial preparation order that talks about the motion in limine. They talk about when they want it and how they want it, okay? There is a meet and confer requirement and a declaration requirement. It's in the local rule. Read it. Here's what I want, and most good experienced IC judges want. I want a binder, and I want every motion in limine, one, and then I want the motion, the proposed order, the opposition, the reply. Tab 2, motion in limine number 2. Literally, I mean, I don't want 80. 3 seems low, you know, a reasonable amount. If you swamp me with 30, I may just say, choose your best 5. Okay, but I'm willing to go. I've done 80 before. It took me a week to do the motions in limine if the case justifies it. Okay, but focus on where you want to choose your battle. Oh, this is the important point, and you've touched upon it. I've seen many motions in limine in bench trials. I kind of smile when I see them because it's not within the definition of a motion in limine. A motion in limine, as both counsel just pointed out, you want to prevent the jury from ever hearing this because you can't unring that. You want to prevent them from hearing that he has 5 prior felony convictions for DUI, okay? You don't want them to hear that. You don't want it to even come out in an opening statement. That's why we have motions in limine for jury trials only. The judge is always going to have to hear it. Oh, we don't want them to, you know, he's been convicted 7 times. Well, they're too remote. They're not, you know, I'll make a finding, okay? And here's my other clue. The rule of court, I mean, the local rule, it says motions made for the purpose of precluding the mention or display of inadmissible and prejudicial matter in the presence of the jury. I just underlined it. So there's your basis. It's only for juries. Now, do I have a problem that you call it a motion in limine and you instead of a trial brief? No. Maybe you do want to exclude this expert from ever testifying because he wasn't designated or whatever, okay? Why am I going to make you spend all that money to bring an expert when I'm never going to, if I'm going to properly exclude them for some reason? wasn't proper. That's the type of motion you want to file, okay? Where it's a practical motion. If not, like I say, it's prison rules. Just bring your stuff. I'll figure out what's relevant. I'll figure out what's triple hearsay. I've been doing this a long time, okay? So, but I'll be honest with you. Maybe there's some judges you need to explain it to them a little bit more carefully. I'll let that simmer, okay? Okay? So, okay, so that's my thing. Here's my other, and I have again, think about the battle you want to choose. Almost all motions in limine should be based on 352. I'm convinced of that. Let me say that again. 352. Because that's the stuff that, for some reason, it might be relevant, but its probative value is outweighed by undue prejudice or undue trial consumption. Most motions in limine should be your good 352 ones, right? Even though it's a fact, we're not disputing it, it's too prejudicial. I always love this. Say, Your Honor, it's prejudicial. Yeah, that's what makes it good evidence. In fact, it's pretty damn good evidence, isn't it? It's really prejudicial against your client. Why am I going to exclude that?
But I'll push back for a second, Judge, and say this. There may be irrelevant pieces of information that the defense or the other side wants to introduce that has nothing to do with the case. It's not a 352, it's just pure prejudice.
Well, no, that is 352, Mr. Kiesel. It is 352.
Well, it has no value.
Oh, you can say 350. I'll give you 351. It's not relevant.
Right.
You can do that, okay?
Right.
But I like it under 352, okay? So, because normally that's what your motion should be about. So really, and I know you all file it, you cut and paste it. Don't argue reptile theory, or the golden rule, or my favorite of all times, which I think Mr. Spillane just did. Exclude all evidence not produced in discovery. Well, that's nice. Did you ask for it? We live in an adversarial system. Okay, we don't have Brady obligations. All right, you specifically have to have asked for it, and they didn't give it to you, and they're sandbagging you. Okay, and I take it like a Kennemore, even though Kennemore technically is about experts. I consider it like a Kennemore analysis. Okay, when you were asked to produce something and you didn't produce it, and now you're trying to produce it and you're trying to introduce it, we're gonna talk about that. Now, here's an interesting point, and maybe I'll throw this out for counsel. There's this motion to eliminate, exclude exhibit 19. Oh, by the way, you should always tell me the exhibits you want to exclude. I'm not gonna just issue a catch-all order. Which exhibits do you want to exclude? You've got the exhibit list. X, Y, and Z, right? Or all, whatever. And then you say, I asked this in discovery. Here's the RFA, the RPD request. And here's their response. And if they say, I'll produce all evidence, we'll comply in full, then we can have a real good discussion. But what if it says objection? Take a hike. I'm not producing anything. And you don't take him to the mat. You don't file a motion to compel further. You let it stay. What do we do now? Mr. Kiesel, what do we do?
I think it's incumbent upon the attorney trying to exclude evidence to have done all he or she can to make sure it's not admitted. And so failure to bring a motion to compel to really know what the evidence is, I think is a problem for the moving party if they haven't done all they need to do to exhaust their remedy.
How about you, Mr. Spillane? What do you think?
Well, I think you have to be specific. You have to say exhibit 19, and you have to prove that they said they'd give it all, or you filed a motion to compel and you got an order to give it, and they didn't do it. It's insufficient just to say, here's something I haven't seen before if you didn't overcome that. I wouldn't file that motion if that's all I got. Just, I asked for the document and I got a bunch of objections and I'm just busy. I didn't do anything else.
Okay, and those are things I'll consider. But to me, the most important is the importance of the document. The more important the document, the more I feel strongly they should have given it to you, because that reeks of sandbagging. You see what I mean? So if it's the classic smoking gun, you're going to have a problem with me, okay? And with any, I think, good judge. But if it's just something innocuous and it really doesn't, I'm going to probably let it go because you didn't follow the motion to compel further. And you can use it to impeach them. You could use it to impeach them. Didn't you say under oath? You know what? These RPDs mean something. The mandatory language. I'm sure you read all my published articles, right? One of them on common mistakes on RPDs. We make you say something for a reason. I'm complying in full. That means something. Or I made a due diligent effort to look and I'm unable to comply. And here's why. Because you can use that language to impeach them later when they were sandbagging you on something or not being straightforward and complete. So anyway, I don't want to develop up into RPDs, but the point back in MILs, choose them wisely. Focus on the ones that really hurt your. Do you care about evidence that actually helps you? I've seen motions in limine filed excluding evidence that actually could help you. You could spin it your way because it just wasn't produced or whatever. Think about this evidence is going to hurt me or mislead the jury. It's got to be some reason, practical reason you want to keep it out. Okay. And then right away, this is what I want out, or I don't want the person to say X, Y, and Z. You know how many times I have to say, what is it that you want out? And you know what I do? It drives me crazy. Counsel, are you intending to elicit that response? No, not at all. Why did we have the motion? Because that's what the meet and confer is supposed to. A meaningful meet and confer says, I'm not going to do that. I'm not going to introduce this evidence. I'm not going to ask that question. You see my point? So I don't really have a lot of confidence that we have a lot of meaningful meet and confers, to be honest with you. Be honest with yourself.
Judge Hammock,
How many times have you said, I agree with that motion in limine, I'm not going to use it?
I would say from my perspective, I oftentimes ask my opposing counsel to let me know areas that they want to bring motions in limine on. And I say, I'll stipulate to that. I'm not going to violate the golden rule. I'm not going to address insurance. I don't want to burden you with the need to rule simply. And I want to have agreement where we can have agreement.
Well, you're good.
I've reached and filed stipulations that we shall not introduce the following evidence and the other side won't introduce this. I take that very seriously. Hey, Judge Hammock, I wanted to throw an issue at you because you said the most popular, the big one is 352. There's a big section in the outline I wanted to mention. I'm seeing a lot of motions in limine on experts, and we've got Sanchez that you can no longer bring in the hearsay.
Sargon, those
We've
are
got
all.
the Sargon, which is the modern
those are
bear.
402
We've got
Yeah.
Kennemer. Aren't you seeing a lot of those?
Yeah. You know what? No, you see them now and then. Almost, we see the same cut and paste. The first 10 are the cut and paste, broad ones that mean nothing to me. I like to focus on the ones that are meaningful, like an expert. I don't want an expert to say this, or I don't want this expert is not qualified to give these opinions. That's a righteous motion in limine. Okay.
And let me tell you the importance for anyone listening, at least from my perspective on motions in limine. I am most concerned about the lawyer's opening statement to the jury. And I want to be certain that that opening statement is going to be the evidence they intend on producing. And I want to make sure I can limit to the extent that there's any vulnerability for my case of issues that they're going to raise to prevent them from making a statement, an opening that is not already established. So that's my purpose in a motion to limine.
That's the key. You don't want the bell rung because even though we tell them disregard it, you can't unring the bell. Okay. Now, and you know what, Mr. Kiesel? And you know what? You've tried cases in front of me. I defer a lot of rulings.
Yes.
I always say you cannot talk about this in the opening statement. You can never mention it until I give the green light. I'm not ready yet. I can't decide in this context. I do that a lot because I need to hear more and hear how you're trying the case and what your theory is before I can make it one way or another. Sometimes it's clear. You're never going to bring this up. Or no, it's green light. You're wrong. Okay, I'm letting this. But a lot of times I just say, and a lot of judges I assume do this, I'm going to defer this ruling, but no one's to mention it.
Yeah.
At anyone in front of the jury. And once you now want to bring it up, you have to go sidebar, ask me for permission to get the green light.
Right. A deferred ruling is a victory in a motion in limine from my perspective, because the jury's not hearing it in the opening statement. A lot of times what the court will do, if it's an expert driven issue, is I'll say, let's do a 402 before that is introduced to the jury, have the witness come in and make an offer of proof. So at least there's a foundation for what's going to be presented to the jury and not just a statement by lawyers in their opening.
No, I agree. And I think we all agree that's the whole purpose is to prevent jurors from hearing something that they really shouldn't hear. Okay. The judge is going to hear it all the time because the judge has to make a ruling at the, under 352 and weigh, weigh the factors into 352. But Mrs. Back to your about point, 402, I see them now and then, but those are more for more complex cases, which, Saragon or
Yeah. So right
Sanchez.
now I'm in the attorney conference room of the complex court today because we've got two trials beginning, one upstairs and one downstairs, and we've got Sargon happening in both departments. We have MILs happening in both places. But here's a couple of points. Number one, make sure you talk to your witnesses about what they can or cannot do with regard to a motion in limine that the court has granted. You've got to talk to your witnesses on both sides to make sure the witnesses don't give answers that violate the court's rulings regarding motions in limine. Right, Judge?
Right, here it is. It's an N in the local rule. It's E. If the motion in limine is granted, it is the duty of counsel to instruct associates, clients, witnesses, and other persons under their control that no mention of display may be made. It's in the rule. I sometimes forget to tell you to admonish your clients or witnesses. I'm generally pretty good at it, but that's your duty. And your duty, if I punt, which I punt a lot, okay? It's always 4th and long in my courtroom, okay? So you have to say, don't mention this. Don't, unless we get the green light, don't ever mention this word or put the slide up or say something like that in front of the jury.
And one more practice pointer is, and I've done this myself tragically, is I've opened the door, having a motion in limine granted at my request. I inadvertently elicited testimony from a witness that then opened the door widely on what I had prevented the court. And I can talk more specifically, but I opened the door against my own MIL.
It's like, what a standard order for me is? I grant the motion to eliminate subject to the opening of the door. I say that all the time. And it's almost reminding them what's good for the goose is good for the gander. Be careful how you ask your questions. Because right now I'm ruling for you. I'm keeping it out. But if you open the door, by the way, counsel, if you think the door is open, just don't barge in. Come sidebar and say, Judge, I think he's opened the door. Okay.
So I'm going to give you a war story. It was 1996. So nearly 30 years ago, I was trying a case in front of Judge Stoll, Gerald Stoll in the Glendale courthouse. And Jack Daniels, the great lawyer, Jack Daniels was the defense attorney. And I had a young girl who died in a swimming pool in an apartment next door to where she lived. And the argument was going to be that the nanny was the one who lost track of the child, which is why the child drowned. That wasn't my theory. My theory was the pool's construction and attractive nuisance. And I brought a motion in limine that there should be no mention of the nanny's failure to supervise. She was not a Prop 51 defendant, no issue. Judge grants my motion. I've got the mother on the witness stand and I say to her, was there ever a time that the nanny lost sight of the child? And as I was saying the last of the words, Jack Daniels popping up and went to sidebar and said, Judge Stoll, Kiesel opened the door. And he said, as wide as you can open the door. And all the evidence came in that I had originally kept out. Yeah.
Buyer
Lesson learned.
beware. Buyer beware.
Thank you.
Okay, one more question before we go on to the next segment, Your Honor. You might have already addressed this generally, but certainly with respect to requests for productions of documents. But with regard to the general point that Jay mentioned about there's a delineation between specific pieces of evidence where motions in limine are generally appropriate and broad swaths of evidence where they're generally not. Where do you draw that line typically?
Hopefully I covered that. I was trying to say, don't just say, disclude all evidence not produced in discovery. That doesn't help me. And like Mr. Spillane said, right on point. Give me the number, the exhibit number. This is the one. You know how many times I've said, what is it you're trying to exclude? And they're like reaching in a book and they were handing it to me. You're like, really? Don't you want to just give me a copy of it beforehand so I can look at it? Because I'll know if it's something that I'm going to exclude. I don't really, I mean, it's not brain science, you know? So that's, I mean, I think that's very important, is that you don't make broad strokes. Be specific. This is the exhibits that I'm worried about, or what someone's gonna say specifically. I don't want this person to say X or Y or Z. You know, don't, if that answers your question,
It
think
does.
you've got to be very, the more specific you are, the more likely I'm to rule and not punt.
I think
Okay.
I was asking more generally with, or more with respect to witness testimony as opposed to documents where you want the exhibit number.
Yeah, but I would do the same thing. I go, and then like I said, I always ask the other side, do you intend to ask that question? And they always say, oh, no. Of course, what's my response? Good, then I'll grant the motion to eliminate. You know, easy peasy. Let's move on to the next one.
Okay, great. Thank
Yeah.
you very much. All right, let's talk about some more specific motions. Jay, do you want to go through some of the motions that you like to bring in your business cases?
Sure. So there's a couple cases that I thought were worth mentioning. Naturally, I like to start with the case that I won, and it's awfully brave of Paul to talk about one where he made the mistake. But so we were the plaintiffs, and it was a joint venture case. My clients were two gentlemen who formed a company, and they went to the defendant and they said, hey, we have a great idea. You have a great product, but there's a whole consumer base you're not selling your product to. We know this consumer base. We'll introduce your product to these customers you've never sold to before, and you'll deliver it. And after deducting the cost of goods sold, we'll split the profits. And so the parties did that for about a year. And then the defendant, maybe because they figured out how to exploit this market, they didn't need my guys anymore, claimed they were merely sales agents and they were fired. So we filed, we were the plaintiffs, we filed basically a breach of a joint venture case. Now, after my clients were fired and the suit was filed, my two clients got into a pissing match over one another and who may or may not have been responsible for what. One of the guys holds a meeting where he fires the other guy under the corporation's code, and it's televised. He videos it, and there's some email where he says he exploited the bleep out of the corporation's code. And the other side was going to introduce this. I mean, to Judge Hammock's point, these were the video and the email were designated exhibits. So I filed a motion under 350, 352, and also, I forget the statute, but it's the one about conduct in conformity with character, saying, look, this was after the joint venture was breached, and there's really no relevance. It's just to show that my guys are quarrelsome dudes who F-bomb one another, and this shouldn't be considered. And the judge agreed with me and granted that motion, so that evidence didn't come in. There's another case that I really wanted to mention because it illustrates larger tactical use of motions in limine as opposed to simply trying to make sure you don't have to unring the bell in front of the jury. I came in on a very difficult case. Prior counsel my client was a defendant, and he was accused of wrongful foreclosure. And it was this crazy loan where the plaintiff borrowed it ostensibly to develop this unimproved property into a kind of a car service and car wash complex. And the kooky intermediaries who had brokered this loan took the money and they went off and spent it on gold ventures. It was crazy. And so the plaintiff sued and said, hey, the money was absconded with, and you couldn't foreclose upon me because I didn't even get the loan proceeds. So there was a bench trial. I wasn't involved in this, and the judge found that my client had committed wrongful foreclosure and had done so with malice, oppression, or fraud. And she purported to say that a jury was going to be convened only for the purpose of assessing damages. So I had one very strategic motion in limine which taught the judge, and I know there's been some questions about whether the motion could be to admit evidence as opposed to exclude it, which taught the judge that it's unlawful, you know, for a jury to award damages on malice oppression based on malice oppression or fraud. It has to be the same trier of fact that finds the malice oppression or fraud. In other words, the judge couldn't instruct the jury that she found it, and they're just tabulating the numbers. So that motion was so effective that the plaintiff conferred about this, and they agreed to avoid the impact of my motion that they'd waive the punitive damages, that you know, they had enough actual damages to you know, warrant taking the case to trial. So that was a strategic victory. The other motion I brought in this case, and I think this may have been the one that got attached to the written materials, is, and this was, we cited Sargon in this one. There was going to be testimony for the plaintiff as to the damages were the lost profits from this business venture to build and operate this car service and car wash facility. And we said, wait a minute, when it was foreclosed, the property was unimproved. And in deposition, I asked this guy whether he had any experience running these particular facilities, and it was pretty thin. So we adduced these cases which would say that when you're talking about damages based on lost profits, it can't be too speculative, right? Obviously, if you know, Apple has a claim for lost profits for not being able to sell iPhones, they've got a pretty good track record, right? But if the business really never even existed, that can be a bridge too far. Now, the judge didn't agree with me. She denied the motion in limine, and the jury did hear that evidence, and that influenced the damage award. But we really kept wrestling with this, and we kept arguing to the plaintiff that that they baked reversible error into this case, and this is going to be a huge issue on appeal. So, speaking of what you do, we wound up resolving this for a fairly good discount off the judgment because of the you know, the interjection of an appeal issue by that motion. So those are a couple I wanted to mention. I thought were used to good tactical effect beyond just keeping out something crappy you don't want the jury to hear.
That's interesting. Beyond the case that you just mentioned, in your practice, have you seen favorable or unfavorable rulings on motions in limine affecting the settlement value of a case and precipitating further settlement discussions on the courthouse steps?
Well, I have. Yeah. Now, of course, this depends on whether you really get the motions in limine heard at the final pretrial conference or the status conference. I know I get judges who just hold it in advance and say that they'll rule on the first day of the trial, hoping you just settle. But yeah, I mean, if you can get it done far enough in advance, I have had the experience that someone taps me on the shoulder and, you know, we get a resolution either before the trial starts or maybe during it, because, you know, the client wakes up and says, I'm not sure I really want to see the end result of this trial with that ruling. And it's so talking about the 3, whether Judge Hammock thinks that's too few, maybe I should up it to 5. But so, you know, certainly a motion that I think would not only practically keep an evidence out, but will interject an issue or cause the other side to have second thoughts or cause the other side to worry could be worth it, even as in the case that I just mentioned, the motion's denied and it laid an appellate issue into the case.
And so that really raises the issue that we're asked. Two questions came in while we were doing this. One is, do you need to have a formal written motion in limine? And the answer is no. In my view, if there's something that comes up in the middle of the trial, you can bring a request to the court on a motion in limine. Judge Hammock, you want to talk about that? Where if someone just says during the course something's coming up and brings an MIL orally?
Wait, you know, I saw as I was typing in the chat. Ask the question again, Mr. Kiesel.
Sure, of course. Can you bring an oral motion in limine? Does that be a written motion? Right. So let's talk about that. So
why not?
The other question, right. So there's 2 points. One is someone says, can you bring
Wait a minute. Don't make it in front of the jury, obviously.
Thank you. So
But,
the
I
other
mean,
is,
you know, I'm not.
in the accomplished court, the judges oftentimes say, if you think evidentially there might be something that's not going to be coming in and it's important to you, bring an early motion in limine. Bring it early, right? So judges do it early, right?
Well, I tell you what, if you think it's gonna help, if I make a decision on one issue, now there's always, someone's gonna learn something. Subdivision T, 437C, subdivision T. I defy anybody who knows that. It's been around for almost 10 years. I've never seen a subdivision T motion. You know what that is? Remember, summary judgments, it has to go to a cause of action, a defense, to the complaint, an issue of duty, a particular damage. You just can't have it to an issue, right? So let's say an issue that would be dispositive potentially, or help you settle the case. You could file a subdivision T motion. I've never seen anyone do it. 10 years in an IC court. Never seen one. Most judges don't even know the statute exists because no one's ever filed a motion. And you both stipulate to hear the motion, and you say it'll help us resolve the case, even though it won't adjudicate the case, because you could always file a motion for some adjudication on a thing that you're allowed to do or something, but it doesn't fit that. It's a subdivision T motion. That's how you do it. And then I can agree or not to agree. Why wouldn't I agree? You're both telling me if I decide this one issue that can't be on a summary adjudication or a summary judgment, but that'll help you solve the case, I'll do it. Now, whether you want to do it as a motion to eliminate, that's fine with me too. If it's going to help you, I have to believe it though. Okay.
Mm-hmm.
So you have to convince me that this motion in limine or T motion, because I still think you have to give the 81 days. But here's the beautiful. Remember, you guys all know this because you all know the CCP by heart. You can always stipulate to less than 81 days, right?
Sure.
You can stipulate to whatever you want. I always say I have all this power. I can sentence people to death, but I can't lower the 81 days. I don't have that power. Only you guys can stipulate to lowering the 81 days. So if you really think it's important, you can, and it's really, remember, like Mr. Spillane correctly noted, you can't file a motion in limine that's disguised MSJ or MSA. You couldn't even do it on a T, right? But if you guys want to all agree, judge, hear this motion 2 weeks before or 3 weeks before the trial, before I have to spend all the time and money working the case up, and this will help us maybe settle the case, stipulate to a quick T. Okay.
Right. So for those watching the presentation, number one, you can bring an early motion in limine if the court invites it, and you can do it. And additionally, you can do it orally during the course of a trial. There's no requirement that it be a written motion, right?
I agree.
Okay.
But, well, yes and no. Remember the rule of court that talks about motions in limine. I think it contemplates a written motion, and so does the local rule. I think you need to, I would hear it as a practical matter, but one could say, this should be in writing because the rule contemplates it, but I can excuse writings, right?
Mm-hmm. Yeah.
Under 128, under that ominous power that the motions are based upon.
So I would say from a plaintiff standpoint, I don't have a notebook of MILs that I bring in every case. I just do not. I look at each individual case and what facts and what issues am I concerned about coming out in this trial that I think they ought not present to this jury. And that is the basis for the motion in limine. It's very fact intensive.
Right. And you know what I generally see? I don't see that. I see a lot, unfortunately, employment law, Song Beverly, that are attorneys' fees driven cases. And I see the same cut and paste motions. Isn't that sad? And it's the same ones, identical. And I'm not saying there's nothing wrong with that, but when you come in with your attorney's fees and ask me for 15 hours for preparing those motions to eliminate, that you've used the same 17 other cases you've had in front of me, I'm a little skeptical about that.
As a pure contingency fee lawyer, I'm always very jealous of the time I spend on all this stuff. So I agree with you 100%.
Yeah. So again, choose your battles. Choose the ones that really make a difference. Don't do it for academic purposes. Okay.
And now here's a question, Judge. I think we gain the favor of the court by not overwhelming you with motions in limine where they're really unnecessary.
Again, I don't do tentative rulings, rarely. I do them on the huge, complicated cases, but I'm not gonna, some judges write out tentatives, I don't. I'll just orally do it from my book. You brought me the book, I'm just saying, denied. Well, I do the colloquy, do you really care about this? No, granted. Do you really care? Oh, denied, and then punt or whatever I do. So I'll give you, and here's what I do. A lot of judges, and I think you should be prepared for this. Most judges want to rule on the motions eliminate at the final status conference, right? Most judges do that, not me. Why do I not do that? Because you guys usually settle. And I'm going to read 5 binders of motions eliminate, and you're going to show up at the FSA, oh, we resolved the case, judge. Okay? I do it a week before. Are you really going to go? Is the train on the track? Is my calendar clear? Everybody's going to go. Then I'll read the motions eliminate. Okay? And then we'll do it on the day of the trial because I'll call the panel the next day. That's what I typically do. It's more efficient. But going back to your point, Mr. Kiesel, I think it's a fair point. Again, I don't, overwhelmed, we're overwhelmed. Yes, of course. But, you got to do what you got to do to protect your client. And if you think there's 20 motions eliminate, follow the 20 motions eliminate. Okay? My average, and I don't mind 3. I think I would love it if it was just 3 from each side. Okay? But I'm more realistic. I'm thinking 5 to 10, I won't really get too concerned. Once it gets past that, it does concern me. And, I've had I just did the Google case, long case, sued for $3 billion. B, stole Google ads. I want you to think about this for a second. Long trial, 3 months. The plaintiff says somebody stole the idea for Google ads. Google ads made $3 trillion in gross revenues in the last 10 years with a T. So this was huge. 3 motions eliminate. They were very complicated and it took me forever to go through them. But these were good team of lawyers, 20 lawyers on each side. They each had 3 motions eliminate. How about that? On a $3 billion case.
I just wanted to pick up a procedural point because Paul brought up you could make a motion orally and you need to be in writing. I had a case in Ventura, which may be a little more in length toward this big multi-month thing Paul tries. Maybe it was like 6 or 7 weeks of complicated doctors suing each other, their breach of fiduciary duty. And every morning the judge would appear on the bench and says, is there anything counsel wants to address outside the presence of the jury? And, and there we did things like, you go to the other side. Hey, tomorrow I see you're bringing witness Smith. Or are you going to try to elicit this? And they say yes or no. And then, you can bring it up to the judge. We've had the discussion and agreed that they're not going to have Smith say this. Or they say, hey, they are going to ask Smith say this. And we couldn't agree. And so we want an order on this. And the judge was fully willing to take that up on that kind of early morning basis without everyone have to put that in writing, or maybe if you had the conversation at 5 o'clock when everyone's going home, you file a 2-pager or something. But
every judge is different. Notice the rule. It's based upon inherent authority and the discretion to control your calendar in courtroom. That's where it's all from. So a judge could say, without abusing their discretion, counsel, it needs to be in writing. Okay? They could say that, and that's a proper order. Or they could do like I do. I always have the lawyers come 15 minutes before the jury, because just in case something comes up, okay? And I got in that group, oh my God, are you ready for this? They were filing between 5 and 10 motions eliminate every day during the trial at 3 o'clock in the morning. So much for the 3 in the beginning, right? I'm not making this up. They both had 20 lawyers. They had teams of lawyers. Yes, especially Google. All right. So, and they were literally filing stuff at 2 or 3 o'clock in the morning. So
upstairs, I have upstairs Google, TikTok, and Meta, Snap, and Instagram. I've got $2 trillion worth of market capital. There's maybe 1,000 lawyers. So I suspect there's gonna be a lot of MILs flying around.
And they did it during the trial. Every single day there was an MIL filed. They did it in writing. But if someone said to me, Judge, I just heard they're going to bring this person that weren't on the witness list, hey, and what are they going to, we're going to talk about it, right? We're going to talk about it.
Well, let me ask you a question, because I have a case going back to a war story. This is about 15 years ago. I had a client who was involved in a rear-end collision. He was in a pickup truck, and a tractor trailer slammed into him and just crushed it. And he had surgery. He was in a coma. But at the hospital, he was a 22-year-old kid. At the hospital, he had a joint in his pocket and $5,000 in cash. Okay. And had nothing to do with this case. There was no intoxication. There was nothing. They did all the blood tests. It was a pure innocent collision. And so I brought an MIL that there'd be no mention of money in his pocket and no mention of the joint in his pocket, and that the motion was granted by the judge. It was clear that, and they were near the very end of the trial. And I've got my client on the witness stand, and the defense attorney says, "Sir, how can you explain that you had $5,000 and a joint in your pocket?"
Well, that person willfully violated the motion in limine.
Willfully violated. The judge
so,
asked the jury out of the courtroom.
What do you
He
want?
said,
Do you want an admonition? Do you want a new trial? Do you
Yeah.
want me to report him to the state bar? Do you want me to sanction him? It's up to you. You've got to make the call.
And that's exactly what the judge did. He basically said, "Mr. Kiesel, if you want to declare a mistrial, I will declare a mistrial. I was 3 weeks into the trial. I'll declare a mistrial and you start again. I can admonish the jury." And that's all I could do. I couldn't possibly have started this trial all over again. And someone asked a question earlier about how you in your closing argument, you weave in the theme that got thrown out there so viciously to just show how bad it is. Yeah, Judge.
Here, I'm going to give you, this is not legal advice. It's an observation. Somebody willfully, obnoxiously violates the MIL because they're begging for the mistrial, right? It's not going well, right? They're begging. They're just you can't create your own mistrial, right? But you know what I would ask the judge to do in that one? Admonish him publicly in front of the jury and tell the jury that he specifically violated your order and that you gave an order. Are those all facts? Be careful for what you ask for. So that might be an appropriate remedy for me, not just to admonish the jury. Don't disregard that. That's not admissible, blah, blah, blah. Publicly admonish counsel. Counsel, I gave you an order. It was an expressed order that you were never to bring this up. And you brought this out willfully in violation of my order. And the jury's going to know that. And you can consider that count in assessing whether you want to believe anything he says that comes out of his mouth, which is not evidence anyway. I mean,
but that's a fair and important point. You cannot do something to invite a mistrial yourself. And that occasionally happens in my practice where the cases are not going well and they sort of do something to invite a mistrial to really do that.
Yeah. And if you do get the mistrial, I would ask for all the money that you spent up to then. But of course, you get a piece of paper that says they owe you money. I don't know what that means.
One of my funniest motions in this trial, I had to fly 2 witnesses up to testify from LA. The case was in Northern California. And I at that time I had a plane. So I flew the witnesses up in the aircraft to testify. And I brought a motion in limine that no mention should ever be made of how witnesses were moved in and out of that court. And the defense attorney said, "I'm not sure I would have asked the question anyway, because the jury would have figured you didn't need it."
I disagree with you, Mr. Kiesel. That might go to bias, and you're flying them first class, and you have a witness that you flew first class. You put him up at the 4-star Beverly Hills hotel. That might be relevant, to be honest with you.
I'm glad I wasn't in front of you.
Okay, I think we're nearing the end of the hour. Paul, I think you mentioned several of your cases and motions that you've either brought or encountered, but is there one more that you want to mention, or do you want to leave it there?
No, I think it's worth saying you have to look at each and every case, and if it's a fact-specific issue that you want to make sure it does not get before the jury, do one of 2 things. Bring a motion in limine to try to prevent it from coming in, or at a minimum, have the court deny it without prejudice, but not allow the defense side or the plaintiff to introduce it in opening. I want to limit opening as much as possible, and the motions in limine are the best way to do that, sir.
Okay. One more question for you, Paul, before we wrap it up. What types of motions are brought against you that you see in your practice, and
Yeah.
what do you think about those?
I would say a lot of the motions involve the photographs of my clients. It may show their injuries. It may show blood. I may want to have X-rays and other things that show the hardware inside of bodies. So it's very common that motion in limines are to prevent visual evidence I want to present to the jury. So I'm always mindful of the fact if I'm going to have a series of pictures that show injury, that they do not show blood, or I can use Photoshop to reduce the amount of blood. I'll do things to clean it up, but that's a common motion that we get to prevent visual evidence.
Interesting. Okay. Jay, what about you? Do you have any final comments that you'd like to make, or things that people listening should keep in mind in their practice?
Well, sure. Since in my business cases, I don't know if this really differs from injury cases, but I tend to have a very expert, heavy set of cases on damages and that type of thing that jury might not be familiar with. Just in terms of practice, it's very important in the deposition. Read Kennemer, and it's very important when you're closing the deposition, sir or madam. Are these all? Have you now told me, either orally or in your report or both, all of the opinions you anticipate speaking to a trial? Is there anything you're still working on? Is there anything that you're halfway done with? If you get that in the deposition, and then the experts are trying to come out with something at the trial that you haven't heard before, then the judges are really going to respect your Kennemer motion. If you don't set that up with that kind of stock cadence at the end, then you open yourself up to the idea that you didn't close the door. So that's a motion I'm seeing more of. I know in this 6 to 7 week doctor fiduciary duty trial, I had a motion because there was a number the expert was going to come out with on a category we hadn't seen before, and we had done a very rock solid job of that. We were able to exclude that because we had the deposition transcript and showed that we shut the door on that. So that's something we should all be keeping in mind.
Great. All right. Before we conclude, Judge Hammock, do you want to make a final comment about the importance that you see in motions in limine? I know every case is different, and there are different ways to do this, but what do you think generally?
I go back, choose your battles, be specific, make sure it's be practical about it. Don't be, academic about it. Okay. And then if you don't mind, there were 2 correct guesses on who I was today. Okay. It was Claudia Melring and Jonathan Terry. Congratulations. When you show up in my courtroom, this will be the symbol for the, like from the movie The Sting, that you get the continuance if you want it. Okay, I can't say it out loud. That looks bad. Okay. But I'll give you another clue for everyone else, if you don't mind. I'm a motivational speaker. I'm 35 years old, twice divorced, and I live in a van down by the river. Anybody? It's Matt Foley's character, Chris Farley, from Saturday Night Live. There were 2 great guesses, other good guesses too. So anyway, thank you all for inviting me. It was certainly my honor and privilege to be with these esteemed lawyers.
Well, thank you very much. There's no better way to end the program than with Matt Foley. Thank you, Judge Hammock, for your time and your outfit. Paul, Jay, it was a pleasure to be on this panel with you. Really valuable insights, and thank you for allowing me to moderate. And
thanks for having us join. Appreciate it.
We're right at 1:30, so the Beverly Hills Bar Association won't get mad at me for ending it early. So thank you all, and I hope those who listened got something out of it.
And go Dodgers.
It goes without saying, for sure.